My name is Ryan Reiffert. I'm an estate and business attorney in San Antonio, Texas. Today, we're going to be talking about the top 10 mistakes that executors make so that you can avoid making those mistakes. Let's dive in. Mistake number one is not really understanding what an independent administration entails. Now, in Texas specifically, independent administration means that there's almost no judicial oversight once you get appointed as the executor. I say almost because there still are a few filings that you need to make with the court, and if you misbehave, and that's the critical point here, you are going to find yourself back in front of the court. In Texas, an independent administration means that you don't need to go to the court and ask Mother May I for every single thing. If you want to open a bank account, you want to sell a car, you want to sell a piece of property, you can do all of those things without the judge signing off on it. In contrast to a dependent administration where you do need the judge to sign off on all of those things. Now, here's the catch. Where a lot of executors misstep here is they hear independent. They hear, okay, you don't need the judge to sign off on it. And they figure, okay, I'm home free. I can just do whatever I want. No, you cannot do whatever you want. If you sell a $50,000 piece of property for $10,000, guess who's making up that 40 grand? You are, because the beneficiaries are going to sue you and you're going to be personally liable for mismanaging the estate. So independent is great. And in Texas, it's the gold standard. Very efficient, keeps the costs down. However, that doesn't mean you can do whatever you want. Mistake number two has to do with creditors. Now, there are two types of creditors, generally speaking. There's secured creditors and there's unsecured creditors. Secured creditors are mortgage holders, car note holders. There's something that's secured by a piece of property. If you don't pay your mortgage, they come take your house. If you don't pay your car note, they come take your car. Unsecured creditors don't have any of that security, or we call collateral. In the state of Texas, the executor is required to give notice to secured creditors within 2 months. If you mess that up, you're potentially on the line for any deficiency. Number two, part of the probate process, you're required to publish what we call a notice to creditors. That's just a notice in the newspaper that says, hey, this person passed, and if you have any claims, here's time to present them. That doesn't bar a claim. What you then need to do as the executor is send what we call permissive notice to those unsecured creditors. If they don't act on that permissive notice, meaning file a claim within 120 days, then their claim is barred. A lot of executors make a mistake. They, A, confuse those two types of assets, and B, they don't send the permissive notice. So if your lawyer isn't talking to you about this, you need to reevaluate your legal counsel. The third mistake that executors commonly make has to do with the inventory. Now, in just about every place that I'm aware of, and certainly in the state of Texas, when someone passes, you're required to file an inventory. What is that? An inventory is a listing of the assets of the person who passed. They owned a house that was worth X. They owned a bank account that was worth Y. They owned a car that was worth Z. They owned some Bitcoins that were worth A, B, and C. They owned some gold bars that were worth D, E, and F. All of those lists of assets are supposed to be published. Now, you might be thinking to yourself, wow, Ryan, that's a massive privacy breach. I don't want every Tom, Dick, and Harry to know what my dad owned or what my mom owned. And you're absolutely right. That is a massive privacy breach. Fortunately, Texas has a workaround. We can file what's called an affidavit in lieu of inventory. And what that means is you file a sworn statement with the court that says, I promise I have given all the information, I have given the inventory, I've given everything to all of the beneficiaries independently, and they're cool with it. And so we don't have to file a full inventory. If your lawyer isn't talking to you about filing an affidavit in lieu in the state of Texas in order to preserve that privacy, that's a problem. The fourth big mistake that I see executors make is misunderstanding the nature of community property and survivorship property. Texas is one of, I think it's 9, it might be 10, I think it's 9 community property states in the country. Now, we could legal nerd out for a minute and talk about how this is like a cool artifact from the Spanish colonial days, and we inherited that into our English common law system, and how it's an interesting hybrid that we have English common law but Spanish community property. You don't want to hear any of that. Community property, if you've ever known anybody who's gotten divorced in the state of Texas, says that, look, Property that you acquire before the marriage is separate property. Property that you acquire during the marriage is community property. If you get divorced, it gets split down the middle as far as community property goes, then you keep what separate property you have, and then you have all this stuff about commingling, yada, yada, yada. If you don't understand those rules of what's community property and what's separate property, then you need to go talk to your lawyer and get some better advice, because the state of Texas treats them differently. You need to understand not only what property is there, what the values are, what creditors' claims there are, but you also need to understand what is its character. Is that property community property or is it separate property? Because that's going to make a difference on who gets what, essentially. And the second big part of this is survivorship issues. You can have a joint bank account, and depending upon the depository agreement with that financial institution, there may or may not be a survivorship rule. In addition, if you have real property that's been deeded to more than one person, depending upon if that deed was prepared correctly, there may or may not be a survivorship right as between the two co-owners of that piece of real property. So this is a place where it's really, really important to have competent legal counsel to determine what are the survivorship rights, what's in the estate, and what's not. Because very often, if things pass by the right of survivorship, it's not considered estate property. And it's a big mistake for you as the executor to attempt to exercise control over property that's not rightfully part of the estate. And you could be opening yourself and the estate up to a whole lot of lawsuits. The fifth big mistake that I see is people misunderstanding how muniment of title works. Now, Texas is cool for a lot of reasons, but one of the reasons is that we have this truncated probate proceeding called a muniment of title. What does that mean? Well, it means that you admit the will as an instrument of title, as a muniment. I don't know, why don't we call it just an instrument of title, but it does not open up an administration. It does not trigger a whole lot of the other requirements that having an executor or administrator would trigger. Doing a probate as a muniment of title is wonderful if all the property is within the state of Texas. Here's where you run into problems as an executor. Most states don't have this muniment of title thing. They don't know what it is. They don't recognize it. They may have heard of it once upon a time. But to them, it's legally not a thing. They're not going to recognize a court order for a probate as a muniment of title. They're just not going to do it. That means that if you do in Texas a probate as a muniment of title, because, and there's some benefit to it, right? It saves you some money. It's less expensive. You try to do a probate as a muniment of title in Texas, then you take that order, that court order probating the will as a muniment, and you show up to, I don't know, let's pick on Ohio. You show up to Ohio and you say, I want this property moved into the estate account. They're going to say, where are your letters testamentary? You don't have them because it was a muniment. They don't have a muniment procedure in Ohio. So what you're going to have to do is you're going to have to go back and redo it. You're going to have to open up an administration and then get letters testamentary in Texas, and then go do an ancillary probate in Ohio. So while your intentions may have been to save a little bit of money and save a little bit of time, and we can all appreciate that, you in fact are going to end up spending more of both, because you're going to have to go back and redo your homework in order to go get that piece of property in Ohio. So it's very important if you're going to do muniment, and I love muniment. It's great. It's a wonderful procedure. My clients are very happy when I tell them, hey, there's this option that we can do a probate for half the price. But if you have property in other states, be careful. Number 6 is people making mistakes with regards to bypass trusts and the portability election. Historically, we use things called bypass trusts, also known as credit shelter trusts, in order to maximize the federal estate tax exemption. Now, the current estate tax exemption at the federal level is approximately $14 million, but some of those traps with regard to a bypass trust and portability remain. Funding a bypass trust prevents the assets inside that bypass trust from receiving a second step up in basis when the surviving spouse passes. Now, for many moderate to high net worth people, that step up in basis is actually more useful than the bypass trust. So a lot of times what we'll choose to do is instead get the step up in basis and just do a portability election, which transfers the unused exemption from the deceased to the surviving spouse. A lot of times that's a much better outcome from tax perspective. So don't just blindly follow the bypass trust. A bypass trust can be great. Historically, they've been wonderful, but don't just automatically do that. You need to do a tax projection first to see which one's going to be the better option for you. Mistake number 7 is commingling funds and accounting failures. Now, under the Texas Estates Code, the executor has a strict duty to account for all estate assets. Commingling your personal funds with the estate's funds is a huge breach of fiduciary duty, and it can lead to not only liability or removal, disgorgement of fees, all kinds of other crazy things. Now, an independent executor, you're not required to file an annual accounting with the court, right? That's the good news. But what you are required to do is you're required to, upon demand, after 15 months, a beneficiary can demand that you provide an accounting, and that you do have to do. If you have commingled funds and you're paying estate accounts out of your personal and paying personal out of the estate and everything is commingled and mixed up, it's going to be really hard to unscramble that egg, and you're going to find yourself in for a lot of unpleasantness in court. Mistake number 8 is relying on separate writings outside of the will if the will doesn't reference them. Now, what a lot of people will do, and I understand the impulse, and this is actually binding in a lot of states, but not in Texas. What a lot of people will do is they'll write down on a piece of paper who gets what, who gets their fine china, who gets their watch collection, who gets their, I don't know what, their Pokemon collection, whatever it may be. They're tangible goods that don't have a title. They'll write down on a piece of paper who gets that stuff, and they'll put it next to the will, but it's not really part of the will. They didn't put it in the will. They didn't notarize it. They didn't have it witnessed. It wasn't part of all the solemnities and formalities that characterize a will execution ceremony in the state of Texas. Didn't do all that. They just wrote it down on a piece of paper. Now, if that piece of paper does not meet the requirements of a holographic will in the state of Texas, if it does not show what we call testamentary intent, it is not legally binding. And if one of the beneficiaries wants to have a fight over the china or the watch or whatever, then you're going to have a fight on your hands because that piece of paper is considered non-binding. Now, there's 2 things to note about this. Number 1, a lot of wills, especially attorney-prepared wills, include a clause that is part of the will that says, I might make a memorandum like that, and that should be considered part of my will. Then you're good. That's fine. A lot of your online wills or fill-in-the-blank wills or even wills prepared by some attorneys won't include that verbiage, and as a result, that written directive from the deceased is not binding. So you as the executor need to know and need to determine, number 1, does that piece of paper convey testamentary intent? Is it a holographic will or a holographic codicil? Number 2, does the will have that requisite verbiage that would incorporate that written list into the will? If you haven't considered those 2 things, you could be potentially giving property to the wrong person and opening yourself and the estate up to lawsuits. Mistake number 9 is premature distribution of the estate. One of the jobs of the executor is to gather all the assets of the estate, determine what's in the estate, determine what the creditors are owed, negotiate with those creditors, maybe lock some of them out by doing a notice, and then pay the claims that are valid. If you start paying out money to beneficiaries before you have taken care of those creditors and before you know that the estate is in fact going to be solvent, and where this becomes particularly relevant is where you have liabilities of an unknown amount. For example, an ongoing lawsuit. What is that lawsuit going to cost the estate? We don't know. Is there going to be a settlement? Is there going to be a massive jury verdict? We don't know. So what the amount of that liability is going to be, if it even is a liability, right? You could get a take nothing. But if there is a liability there, we don't know the amount of it. So to the extent that you make distributions to beneficiaries, you could then be on the hook if the amount of those liabilities comes back as being greater than the assets of the estate. They're going to look to you personally as the executor. So you should really, really be careful because the estates code does provide clawback mechanisms. Last but not least, the 10th major mistake that I see executors make is failing to communicate with the beneficiaries, failing to let them know what's going on. Hey, I listed the house for sale. Hey, we've got to fix up the house before we list it for sale. Hey, do you know anybody who can fix up the house and list it for sale? If the executor isn't having these conversations with the beneficiaries, or at least letting them know what's going on, I see a whole lot of fights occasioned by surprise rather than any actual unfair or nefarious behavior by an executor. They haven't been kept in the loop, and that ends up in them being pissed off about it. So, number 1, as the executor, my first piece of advice when somebody comes into my office as an executor or potential executor will, I say, look, open up a group text with the beneficiaries. Put everybody on the text, let them know that you're hiring a lawyer, that we're going to go do probate, that you think these are the assets of the estate. And do they know anything? Do they have anything to contribute? Because a lot of times, you as the executor, you might not know everything, right? Now, they may have some information to contribute to you, and they're interested in doing this too. So including all of those people on the discussion, even if you don't end up doing what they want you to do, that their concerns get heard, even if they ultimately disagree with what you do, even if they ultimately don't see things the same way as you do, they've at least gotten to speak their piece, right? And that heads off a lot of conflicts before they even begin. So you as the executor need to be in regular contact with the beneficiaries. It doesn't have to be a group text if you don't want it to be. That's just my suggestion, because a lot of times that's the easiest way to update people. Now, there's one big caveat to this. If everybody's already lawyered up and there is already a fight and there is a lot of animosity involved already, don't text your beneficiaries, right? All that conversation needs to flow through attorneys, unfortunately, and everybody gets to rack up a big legal bill, but that's the reality of an estate fight. Everybody's gonna spend a whole lot of money. Other than that, if there's not a fight yet, if there's not an animosity yet, keep everybody in contact and you'll reduce the chances of there being a fight. And that doesn't mean you have to do everything the beneficiaries tell you to do. You're the executor, you have the keys to the car, you get to make your decisions. Now, if you make a bad decision that violates fiduciary duty, you could be sued for it. Point is, keep your beneficiaries in the loop and you'll avoid a lot of fights before they start. I hope all these tips were helpful to you guys. If you want more insight into what an executor can do to avoid liability or pitfalls that are common for executors, send me an email, give me a call. If there are other topics that you want to see, please put it in the comments. I'll do my best to cover it in a future video. As always, thanks for tuning in. Like, subscribe, and I'll talk to you all next time.